Good afternoon. My name is Henry Emmerich. I'm an executive partner in the Grand Rapids office of Secrest Wardle. I've been handling insurance-related litigation for most of my career. Today we're going to talk briefly about the business interruption claims that we're starting to see as a result of the shutdowns imposed by the governor's emergency orders. What we've seen in these cases thus far is that most of these shutdowns have not alleged any actual contamination of the premises by COVID-19, but they are alleging that the business income loss that they've sustained because of these shutdowns is something that is covered by their commercial business property insurance policies. What we'll talk about today is why it's our position that most of these claims are not covered by the traditional business interruption policy that most of us are familiar with. And in connection with that, we're going to talk about why we do not believe that coverage is triggered by these emergency shutdown orders. When you look at the typical business income and extra expense coverage, there's most of the provisions in the policies are relatively consistent because a lot of them are based on ISO forms. And if you look at those provisions, and we put the typical provision up on the screen, it states that we will pay for the actual loss of business income you sustain due to the necessary suspension of your operations during the period of restoration. And this becomes very important, this language that we've highlighted. The suspension must be caused by direct physical loss of or damage to property at the premises which are described in the declarations, and for which a business income limit of insurance is shown in the declarations. Also important is the next sentence, which says that the loss or damage must be caused by or result from a covered cause of loss. Again, this is the language that is at issue in these cases, and this is the language that we believe that the companies can rely on to deny coverage in most of these claims. Now, this particular language is not defined in the policy, but when you look at the case law, and some of the case law that we'll discuss later in our presentation, you'll see that the concept that we're talking about here is that there is no direct physical loss of or damage to the insured property. And that's the concept that we are focusing on today, and that is the concept that we believe all of you should focus on when you analyze or receive these claims. This language that we just talked about, as indicated, is the most critical language in the policy to determine whether or not there is coverage for a loss of business income alleged to have been a result of these emergency order shutdowns. Additionally, and the additional coverage form that is often argued about or asserted as a basis for the claim is the additional coverage caused by the shutdown of other businesses in the vicinity of the insured premises, including businesses shut down by civil authority. And again, when we look at the policy and the language, we're dealing with a provision of the policy that is based on an ISO form, and we've put it up on the screen for you to look at. And it again references a covered cause of loss causing damage to property other than the insured premises. Perhaps a good example of what we might be talking about here would be a situation where a mall in which a number of businesses are located is shut down by the emergency order because of the gathering limits that are imposed by these emergency orders. And as a result, the mall is shut down so that no one can enter the mall. And ingress or egress to a particular insured business is limited to access or requires access to that mall, and because of these emergency orders, you then can't enter these businesses, so they have to shut down as well. And in those situations, the business itself may not have been shut down, but the mall or facility in which the business is located is shut down. And again, access is denied, so the insured business has to shut down. So again, when we look at the policy provision at issue, the provision that is up on the screen is what is often asserted as a basis for the business income loss claim. And again, when you look at the language that we're talking about, the reference again is to a covered cause of loss causing damage to property other than property at the described premises. And again, when we look at these situations, we look at access being limited or prevented to a certain property in which your insured business is located, or something happens with regard to the mall that prevents or makes it dangerous to enter that mall and in turn your insured businesses. So again, that's what the typical example that we're talking about. And if you look at these situations, when you compare it to a typical situation that might result in coverage, we'd be talking about a situation where, say, we had a fire in a mall that rendered the access to the mall or entry into the mall dangerous. So there's actual damage, physical damage to that property because of some sort of covered loss that then makes it dangerous to go into one of these insured businesses. So the entire mall gets shut down, resulting in the closure of your business and the loss of business income. And those are the situations, a very clear example of what would be covered in that situation, which is not the case when we're dealing with these shutdowns because of an emergency order. So that's the other clause that's oftentimes asserted by insureds as a basis for coverage for loss of business income. Now, in both of these cases, what we look at from the outset is what exactly is it that resulted in the shutdown of these businesses, of your insured businesses. And again, as indicated in the screen that you're looking at right now, the requirement is that the covered cause of loss causes damage to the property itself. And in both of these situations where we're talking about the insured premises itself, or we're talking about surrounding premises that are shut down and as a result access to the insured business is prevented, we're talking about the direct loss or damage to the property at issue. So when you look at the covered kind of loss, then you go back to your policy and you look at what the risks of physical loss entail. Is it an all-risk policy? In other words, any risk not excluded, or is it specifically a named peril in the policy? And again, you have to analyze whether or not there's been any actual damage to the insured property in order for coverage to be triggered. Again, what the courts have suggested is that there must be specific, tangible, or material loss or some sort of an impact on the insured property that's tangible, material, some sort of effect on the structural integrity in order to trigger coverage under the business interruption policy. When we look at the COVID-19 shutdowns, most of these shutdowns were across the board. They weren't based on a specific property having been determined to have contamination as a result of COVID-19 on site. And most of these businesses are simply shut down because of the emergency order and not because of any contamination on that property. And when you start looking at these claims, I think one of the things that you also want to look at, and it's very important when we're talking about whether there's been any contamination on site, is whether your policy also has a virus or bacteria exclusion, because that could make a big difference if, in fact, one of the businesses has sustained some contamination. When we look at the legal rationale for the position that we believe the insurance company should take, and that is to require that there be direct physical loss of the insured property, there's a case that came out a few years back in the Eastern District of Michigan, which is entitled Universal versus Chubb Corporation. And in that case, they discussed the requirement in Michigan that there be direct or actual physical loss to an insured property before coverage is triggered under a typical business interruption policy. And if you look at that case, there's a couple of key points that come out of it that make this analysis understandable. First of all, they talked about the concept of direct, and they indicated that the concept or term direct requires or indicates that there be some sort of immediate or proximate cause, something that happens right away because of this covered cause of loss. It talks about the fact that it has to be physical, and in this context, what is meant by that is something that has a material existence. In the Universal case, there was what was involved, the contaminant involved, was mold and bacteria that had accumulated on the floor of an office building. It was subsequently cleaned, and the mold and bacteria were removed, and the structural integrity of the wood was not impacted in any way once it was cleaned. And therefore, as a result of that, the court said, well, there wasn't any kind of permanent or direct physical loss of or damage to property, because once it was cleaned, it wasn't there. So when you look at the concept of direct physical loss and you analyze it in that context, Universal versus Chubb Corporation went on to say that the direct physical loss concept of the business interruption policy contemplates that there be some sort of an actual change in the insured property that has occurred because of an accident or some sort of fortuitous event. Again, that covered cause of loss, whether it be in an all-risk policy or a named peril in a named peril policy, that results in the property becoming unsatisfactory for future use that requires some sort of repair to make it satisfactory. When we look at the mold and bacteria permeation on the floor in the Universal versus Chubb Corporation case, that wasn't what we were dealing with, because simple cleaning of the floor removed the condition and there was no need for any repair of any sort. In our view, most of the claims that are being made for business interruption because of COVID-19 are not going to prevail for this reason. There has to be some sort of physical damage to the insured property, as discussed in the Universal case, and it has to be something that is permanent in nature, so that there has to be some sort of remedial action taken in order to restore the property, and that's not what we've seen in most of the cases that have been brought thus far. In fact, in a case just decided, there's been a couple of cases that have been decided in the last couple of months in the state of Michigan that have followed this rationale and ruled in favor of the insurance carriers in those cases. The first was a case that we were involved in, entitled Gavrilati's Management Company versus Michigan Insurance Company, which was brought in the Ingham County Circuit Court. And in that case, the allegations in the complaint specifically stated that there was no contamination of the insured property, that there was never any contamination or infection of any person that had been on the property, either in the form of an employee or a customer. And those were the allegations in the complaint, and we filed a motion to dismiss as our initial pleading, and the court focused on the fact that there was no direct physical damage to the property of any kind and dismissed the claim. The other case came out of the Eastern District Court of Michigan and then Federal Court of Michigan, and it involved the case entitled Turek Enterprises, Inc. versus State Farm Mutual Automobile Insurance Company and State Farm Fire and Casualty Company. And this case was just dismissed 2 weeks ago. And in that case, the court focused on, again, the lack of any sort of physical damage to the insured property in the case, and as a result of that, determined that coverage wasn't even triggered. So again, both these cases, and in particular the Turek decision, provide an excellent discussion of what we're talking about here, what this concept of physical damage, direct physical damage to the insured property is that has to occur before coverage is triggered. And I think when you look at those cases, you'll see that any claim that you're facing is likely not going to survive a motion for summary disposition for the reason that there hasn't been any contamination on the property. Again, it's important to understand that if that is the case with the claim, you don't even have to get to the issue of whether or not your policy contains a virus exclusion. In other words, the court doesn't even have to get to that issue, although in the Gavrelati's case, for example, the court also decided that issue in favor of the insurance company. If you look at these cases, what the arguments that the plaintiff's attorneys try to do to get around this direct physical loss requirement is, for example, in the Gavrelati's case, the plaintiff argued that because its client, the restaurant group, was unable to simply use their premises because of this emergency order, that constituted this damage or physical loss that needed to be established to trigger coverage. And again, the court in Gavrelati said, no, that's not what the policy says. The policy doesn't talk about loss of use. It talks about the requirement that there be damage or actual damage to the property. And again, because there was no such damage, it didn't matter that there was a loss of use brought about by the emergency order. A second argument that was made in that case was that when the governor allowed these businesses to open, they required certain modifications to the property. And those modifications actually were repairs, if you will, that they claimed established the requirement of some sort of tangible alteration of the property. And again, the court went back and says, no, that's not the case. These were remedial measures that were put in to allow social distancing, allow spacing to occur so that the restaurant could then open up for dine-in business. And they were brought about because of this requirement for social distancing and not because of any direct physical loss of or damage to the property. So again, same analysis was applied to those claims, and the court said it didn't satisfy the requirement or trigger that there be direct physical loss or damage to the property. The other argument that has been made in some of these cases is that as a circumstantial proof of some sort of transmission is that COVID-19, because of its rapid transmission, it likely permeates the services or fixtures of businesses where someone has come in that's been contaminated, and as a result of that, there is likely going to be some kind of contamination. Now, there has been one case in the country in the last several months that has at least survived the early summary disposition based on that allegation, but in our view, once the case works its way through the system, that case will likely not prevail again because it's doubtful that they'll be able to prove in that case that there has been some sort of actual structural alteration of the integrity of the building or direct physical loss, which again is required in order to trigger the coverage. And even in that case, the court indicated that they were basing its decision to deny early summary disposition on the mere fact that the allegation had been made in the complaint. And as we know from the science that's developed and evolved over the last several months, surface transmission is often, if not indicated to be very unlikely. And even if there is some sort of surface transmission to surfaces of a premises, cleaning will remove it without resulting in any permanent or structural damage to the property. And because of that, we're back to the situation that we talked about in the Universal case, where the mold and bacteria was simply removed from the office building by cleaning. Finally, the last argument that we've seen that's been made in these cases is an indication that once the property is shut down, some sort of a deterioration occurs, either from some fungible product on the property, for example, like medications in the or products that are used for whatever the purpose of the business is, that deteriorates over time because of the fact that nobody's maintaining the business, or that the products simply expire because they're not used when they're supposed to. And again, the argument in that case, in those cases, is not going to succeed because, at least according to the Turek case, the deterioration itself was not a result of some sort of damage to the building that was caused by an accidental or fortuitous event. And again, as in Turek, the court indicated that the analysis still has to require that the original event that shuts down the business was this accidental or damage to the property, the insured property, and it hadn't occurred, so they got around it in that case. And there's also some numerous exclusions in the policy that can be asserted that are based on wear and tear or deterioration that will exclude that damage as well. Even in these cases where you might have some actual contamination alleged, it's our belief that if you focus discovery in those cases right from the outset on establishing that there's been no kind of compromise or of the structural integrity of the building or any sort of permanent damage or contamination that cannot be removed, you'll be successful in obtaining summary disposition eventually, again based on the concept that there's been no tangible physical damage to the property, in keeping in line with these other cases that we've been successful on. In these cases, even where you may have a situation of direct physical loss, most of these policies, many of the policies, you shouldn't say most, provide a virus exclusion. Again, we've set up the typical virus exclusion, and it reads as indicated on the screen, and it basically says that we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. It should be noted that these exclusions started appearing in policies back in 2006, 2007, when we had the SARS virus around, and it was submitted to ISO for consideration. And when it was submitted, some of the viruses talked about were referred to as coronaviruses, which is exactly what the COVID-19 virus is. So it's our belief that that will be sufficient to knock these claims out, even if you can't get around the lack of physical damage to the property argument that we believe most of these cases will be successful on. It's important to understand when you look at these cases that we're talking about losses that are very significant. It's important because of that you thoroughly investigate these claims, that you make reservations of rights that are specific to the claims that are being made, and that once your investigation is complete, that you deny it in writing with specific references to the possible coverages that might apply and the facts that you've developed in your investigation that support the denial. We've attached a sample denial letter that was attached as an exhibit to the Gavrilotti's case, in which was the basis for the denial in that case by Michigan Insurance Company. And as you can see from that letter, it's very specific with respect to the coverages that are being asserted under the policy, and it's specific with respect to the factual investigation that was conducted and determined that there was no actual damage to the property, and it's stated in the letter as to why it was not supported. We also recommend you throw a general reservation of rights into those letters because, again, there may be facts that are not known at the time of your initial investigation. But the important point that we want to make when you look at these cases is that when you deny them, that your investigation be cited and that you make it very clear as to what facts support your denial of the various claims. In each of these cases, it's imperative that you look at the policy in its entirety and that you make certain that all of the potentially applicable provisions are referenced in your denial correspondence. If you do that, it's our view that you should be able to successfully defend these claims and deny them for the reasons that we've talked about here today. Thank you.